Buckle up, folks, this courtroom isn't just handing out justice, it's dishing up drama. Today's case opens with Miss Ebony Allen, a name the judge instantly recognizes from a rap sheet that reads like a criminal history bingo card, multiple convictions from 2005 to 2024. And what starts as a routine check-in spirals into a fiery confrontation with law enforcement, credibility clashes, and a judge not having it. We've got a defiant defendant, a frustrated judge, a flustered attorney, and yes, multiple that never happened outbursts. But here's the twist. It's not just about what happened, it's about how it's said, who gets believed, and what happens when the courtroom becomes a battleground of perception versus paperwork. Is this another case of over-policing and miscommunication? Or is the defendant playing the victim card too late in the game? Stay with us, because in the next few minutes, we'll break down major turning points, explain the legal stakes, and give you our take on who's in the right, who's in the wrong, and why this might be one of the most intense showdowns we've seen in months. Let's get into it. Fire.
All right, do I have Ms. Ebony Allen Hunter Smith, 22W29943 A and B? Are you going to talk to the prosecutor, see if you can resolve that or not? Where's Mr.
Can we see you in chamber?
You can see me wherever you want. You can see me now, can't you? You look at me right now. I'm just kidding. I want to get her lawyer out there. I was just going to see if you guys, before I call the case, if you can.
I think we might be able to resolve.
Okay, hang on.
Possible.
Mr. Crawford.
My name? Michael Crawford, representative defendant.
Ma'am, your name.
Ebony Hutchison.
This is a who's who of criminal convictions here, huh? What am I going to do with her, Mr. Crawford?
You have an opportunity to show you how successfully she can help.
I'm sorry?
For an opportunity to show the court that she can successfully complete.
I didn't like the way you were acting with the police officer. You know that. I looked at a young lady with a larceny in a building. I mean, you got multiple convictions.
Well,
Ma'am?
When the judge starts rattling off charges from 2005 to 2024, he's not just reminiscing, he's laying the groundwork for what's known as sentencing context. Judges often review a defendant's full criminal history to determine patterns, assess risk, and make calls on bond, diversion, or even jail time. And when he says, this is a who's who of criminal convictions, he's not being poetic, he's pointing out a documented pattern of recidivism. It's also important to note that disrespecting officers, as this report alleges, plays poorly in court. Judges take issue not just with crimes, but with attitudes that suggest defiance of authority. That's why this history isn't just being read out, it's being used to set the tone for how seriously the court is taking this case.
Ma'am?
Can I explain the motion? That was when I was.
You don't even know what I'm talking about yet. Let me finish. Then you can explain. Okay? I mean, you were born in 86, right? So you aren't exactly ancient. You're 39 years old, right?
Yes.
You got convictions in 05. I mean, you got some bad stuff going on here. 06, 9, 10, 10, 15, 22, 22, 18, 24 was disturbed the peace. But I just don't like when people treat officers with this kind of disrespect. He's telling you he pulls you over.
No.
Did you pull yourself over?
I was already pulled over.
Okay. He says, I'll just read. I observed the black Jeep accelerating towards a white pickup that was slowing in the roadway. The Jeep made an abrupt movement to the left and attempted to overtake the pickup on the left side. I activated my emergency lights and siren and pulled behind the Jeep. The Wrangler stopped abruptly in the middle of the road, and the driver, a black female, exited and began to approach my vehicle.
That never happened.
Okay. I'm just going to read the rest of this. I opened my door and issued multiple commands for the driver to return to the vehicle. She immediately stated, quotes, no, and mentioned that, quotes, I would have to kill her. The driver began taunting me and verbally refusing my commands to return to her vehicle. I requested additional units and attempted a fifth and final time to order the driver to return to her vehicle, and she stated, are you going to kill me? Question mark. No, question mark. Then what are you going to do? Question mark.
And there it is, that never happened. The defendant directly contradicts the officer's report, claiming she was never pulled over and had simply stopped to ask for directions. This right here is the crux of courtroom drama: credibility versus documentation. The police report is detailed, timestamped, and follows procedural language. But the defendant's story, that she just popped into a gas station while lost from a Christmas party, tells a different tale. But now we ask you, who do you believe? Are we watching a woman wronged by an overzealous officer? Or someone rewriting history after realizing the consequences? Drop your take in the comments. Is this a case of mistaken intent, or a masterclass in denial? Backhand index pointing down.
Mark. I use soft open hands to turn the driver around and place her against the front hood of my patrol vehicle. Sure, I'm just asking. That's why I'm bringing it up.
Never happened.
He's lying?
I was coming from a work Christmas party and I was lost. I live in Warren. I got off the freeway and I seen a gas station. I pulled over at the gas station and to go in to ask him where I was, and when I came out, that was the only time I seen the officer, and he grabbed my arm and I was asking what happened. I never was pulled over. I was never pulled over. I pulled over. I did realize I was drinking. I was over the limit. And I pulled over and I went inside, and that never happened.
So you never said,
I would like to see a video. That never happened. That's a whole lie. And the thing that you said earlier, that was 20 years ago, that was when I ran away from my grandmother. And I took my stuff and I sold it. I didn't break in a house.
listen,
Please.
listen.
That's just a lie.
Okay. So if your position is the police officer is filing a police report contained with lies?
That's absolutely.
Okay. So you deny,
I would like to see the video.
hang on, so I'm just asking you, so you deny telling him that you're going to have to kill him?
That's crazy. That's crazy.
Okay, fair enough.
When the judge says, "You've interrupted me 5 times," that's not just a scolding, it's a warning shot. Courtrooms are governed by decorum, and repeated interruptions are not only disrespectful, they can actively harm your case. Judges look for remorse, cooperation, and respect. Whether the defendant realizes it or not, she's stacking the deck against herself in real time. This isn't just about the facts, it's about behavior in the courtroom. And this judge? He's not one to let chaos slide. Pro tip: if you're in front of a judge who can count your interruptions out loud, you're already on thin ice.
Mr. Crawford, is everything in this report accurate?
I've had the opportunity to review both client. We believe that recommendations, generally speaking, are fair. There are a couple revisions that we're requesting.
Take back my bill. I want a lawyer, and this is insane. I want to see the videotape, and that's a flat out lie. It never happened. That never happened.
I don't even know if they'd have the video anymore because you didn't show up. Ma'am? I don't even know if they'd have it anymore because you didn't show up when you were supposed to. You weren't here in 2020. Ma'am? Stop interrupting me.
They don't maintain dashcam video for that long. That sentence might sound small, but it has massive implications. Dashcam footage could have been the key to proving or disproving what happened during the stop. But because the defendant failed to appear in 2020 and again in 2023, the time window for preserving that evidence closed. That's how due process and responsibility intersect and sometimes collide. If you don't show up, you lose access to the very materials that could clear your name. Here's the lesson: the justice system might move slow, but it doesn't wait forever. Evidence expires, and so do opportunities.
2023, you were supposed to be here. They don't maintain dash cam videos or other videos for this length of time. Okay, so I doubt there's any that exist. So let's just start with that. Settle down. I can tell already that while this may not have happened, you have a real problem with authority. You thought you just interrupted me 4 or 5 times when I was trying to talk to you, so you don't have any respect for me either. But that's not the point. The point is I'm looking at somebody that has significant criminal history, man. And I thought, in fairness, I'm going to offer you the opportunity to explain to me whether or not that was true. Look at me, please. Whether or not that was true. Seemed very disrespectful to me. That's just me. Now, counsel, does she want to go forth? Because this has been 3 years now. So I'm not likely to ma'am, who's this with you here? Who are you, sir? Maybe she needs to go talk to you for a minute, and then we'll recall the case. Okay, maybe you can calm her down. But I don't appreciate her constantly interrupting.
She doesn't need to figure out.
Well, she did it multiple times. I don't know how I can conclude otherwise. All right. Do you have another one for me?
No, not right now. You got one more up to.
Who's this in the back? What do you guys have?
Logan.
Okay. What did you want to do? You want to talk to me? You said something about going in chambers.
Yeah.
Well, you got to get the prosecutor.
No, I know. They asked me if we could,
Who asked you?
the pastor said, do you want to go talk to the judge and see if we can resolve it? I said, yeah.
Well, I'm not the prosecutor, though. I'm not.
No, the pastor told me.
I know. Get him in here, John. Mr. Uric, Mr. Bulahanis said you would like to talk to me with him. Is that right? Okay, come on in with him. We'll go in chambers, the three of us. All right? Thank you. Come on back.
Thanks.
Yes, I am.
Oh, no, sorry. First. Sorry, Bob. I said, sorry, Bob.
Okay,
Thanks. Have a good day, Jeff.
let's go to Fuller. Andre Ramon Fuller. 18B 133523A, 14B 74531B.
Good morning, Your Honor. Attorney Torrey Westmoreland, appearing on behalf of Mr. Fuller. Fuller, please state it on the record. Not grateful.
I also have one 8B 133523B. I can't wait to hear.
Your Honor, at this time, we're prepared to vote formal reading of the client's statement.
I'm just curious. What made you walk in to
I thought I was being elected President of the United States. Okay, pause. That line is pure bench sarcasm. The judge is roasting the defendant for walking in 11 years late and expecting leniency. It's almost comedic if it weren't so tragic. This is where justice meets disbelief. Not only is the judge rejecting the request for a personal bond, he's making it clear that your absence from court doesn't get erased just because you finally showed up. Here's a question for you: if someone skips court for over a decade, should they still get a break if they eventually come back? Or should that door stay shut? Sound off below, we want to hear your verdict. Adult balance scale.
walk in to 11 years after the fact on this 2014 case? Hang on, I'm not done. And then, what made you walk in on this 2018 case today? You haven't been here in 11 years and 6 years. If he thinks he's walking out with a personal bond, he's got something else coming. I'm asking you a question. Why did you not show up on these cases? Why do you think that you're larger than life? I don't like this.
I went to get my CDMs when I went to.
Maybe we don't want to move the case now. Maybe we don't want to move the case now. Maybe I want to set this in 7 years. That's what I feel like doing. You feel now you need something, so you want to walk in here? Are you kidding me? What am I talking about? Is that what you said to him?
That's not what you said, Judge. Your Honor, he was under the impression that when posted a bond on him.
Uh-huh. And I was under the impression when I got elected district judge in 94, they were electing me president of the United States. I really don't want to hear it. I really don't want to hear it. 3,010%. 3,010% on 5238. And so with all these new rules, if anybody wants to criticize me on this, I just want to make it clear that Mr. Fuller here didn't show up in 14. We issued a warrant. He forfeited bonds. He didn't show up in 18. He forfeited other bonds. So, you know what? I don't care if he can post or not. 3,010% on 531B. I get tired of this. Like, who would you think you are to do this? I'm serious. I mean, who would you think you are? No respect for the system, eh?
I've been trying to get my.
You haven't been trying to do anything.
Yes.
I don't want to hear it. You're going to sit down there or you're going to post $600. If you're not going to post $600, you're in custody. Or is he just assuming he can walk in 11 years and I'm going to give him a personal bond? Do you have the money to post the bond or not?
Yeah.
You pull this game with me again, I'm telling you next time you'll be sitting in there. I'll make sure of it. Well, and then he looks around like, what's wrong with this judge? He thinks I'm not showing respect because it only took me 11 years to come in here and see him.
Stroke, son.
You were getting picked up and arrested on other cases. You posted bonds and then you didn't show up again. Now you send your lawyer in here to tell me that you thought the case was taken care of. Really? I can add 3 and 8 without a calculator. I don't want to hear it. What date am I giving them here, Lisa? I had it written down. I don't know. This is Brownstone, I guess, both of them. So I'm setting it for November the 5th at 11.
2 cases. 2 defendants. 1 courtroom that refuses to play games. What we witnessed here wasn't just legal proceedings, it was a clash of authority, accountability, and courtroom candor. In the first case, the judge confronted years of criminal history and a defendant who claimed innocence but fought the system at every turn. In the second, a man tried to walk back into court after more than a decade and left with a reality check and a $600 bond. Bottom line? The courtroom doesn't forget, and it definitely doesn't forgive missed appearances. Respect, timing, and truth matter. Direct hit. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. This was real, raw, and straight from the bench. We'll see you in the next session.